Good afternoon, everyone. Thank you for joining our webinar today, Adult Guardianship Updates from the 2018 Legislature. My name is Vanessa Sanchez, and I'm the CLE Coordinator at the State Bar. I'd like to introduce our three speakers today. First, we have Lisa Millick. She is a Vice President and Wealth Advisor with New Mexico Bank and Trust, where she administers trusts, conservatorships, and other types of accounts. We also have Felice A. Rayel, who is in private practice at the Law Office of Felice A. Rayel in Albuquerque, New Mexico, where she concentrates her practice in nursing abuse and neglect, personal injury, criminal defense, and guardianship and conservatorship proceedings. Last but not least, we have Gregory W. McKenzie, who is currently an attorney with Hurley, Tove, Stiles, Hamblin, and Panter, where, amongst other things, he frequently handles litigation in contested complex guardianships and conservatorships. So without further ado, I will let them get started. Thank you.
Hi, everyone. Thanks for joining us. The purpose of today's teleconference is to discuss the revisions to Article 5 of the Uniform Probate Code that were made in the 2018 legislature. And so what we'll do today in the hour that we have is to go through some of the background to those changes, to give you some context, and then walk through those changes as best that we can. On the screen in front of you, and hopefully we've got our technology right, you will have a copy of SB 19, which was the act that was passed in this legislature dealing with these changes. So let me start by just briefly touching base with you concerning Uniform Probate Code, which New Mexico has had in place for a number of decades. New Mexico is a UPC state, as well as about 24 or so other states in the country. The Uniform Probate Code, interestingly, has served as the basis for modification for statutes even in states that don't have the UPC. But what's significant to note about New Mexico is that after the adoption of the Uniform Probate Code in New Mexico, the Uniform Law Commission continued with various revisions to the code over the decades. New Mexico had a number of, well, a couple really, of significant modifications to its version of the UPC, but for the most part did not keep up with the changes to the Uniform Probate Code as they trickled out of the Uniform Law Commission over the years. A number of symposiums and professional conferences occurred over about a 20-year period, the last one being in 2011, and that conference resulted in the Uniform Law Commission reconvening the drafting committee for the Uniform Probate Code to look at further changes to the guardianship and conservatorship portions of the code. That drafting committee began meeting about 2 years ago and followed some recommendations and core standards developed during that 2011 symposium that I mentioned, including looking very carefully at how do we make our law more person-centered, incorporating the concept of substituted judgment in a more embedded and deep level, looking at least restrictive means, supported decision-making, visitation, and then monitoring issues. The Uniform Act emerged in July of 2017 when it was read at the floor of the Uniform Law Commission in San Diego. That act, of which I had the pleasure of sitting on the drafting committee of, really was a complete rewrite of the guardianship and conservatorship law. Our existing probate code is divided into 4 sections. The new act looked at these sections and actually added a section which we'll talk about, and really hit some of the main issues, including redefining terms from incapacitated person to respondent, streamlining pre-adjudication procedures, and dealing with some very hot-button issues that are prevalent across our country, not just in New Mexico, but prevalent across our country with people being very dissatisfied with the current kind of American guardianship architecture. Those hot-button issues included visitation, dealing with confidentiality, dealing with access to court files, dealing with conservators' ability to sell primary residences of conservatees, etc. Also, the Revised Act dealt with monitoring, improving monitoring by improving notice of the proceedings and improving and adding people who got notice of the final hearing for the adjudication of incapacity. The Revised Act included references to forward-looking guardianship and conservatorship plans, and also provided really good guidance for laypersons in making decisions as guardian and conservator. So ultimately, this act was approved by the Uniform Law Commission in July, and then came to New Mexico in the fall. In truth, though, the Uniform Act emerged really among a lot of controversy over guardianship countrywide. And that controversy included controversy that emanated out of a couple of high-profile cases, especially dealing with visitation. Now, because visitation becomes an important modification to SB 19, I think it's worthwhile to give some context to some of the controversy that has emanated over visitation and guardianship and conservatorship. And Lisa, why don't you talk briefly about some of that context?
Sure. Well, visitation comes up mainly in this context of adult children who, for whatever reason, were unable to have visitation with their incapacitated parents. Two of the main cases I want to talk about because they resulted in legislation. The first one is Carrie and Casey Kasem. You may remember Casey Kasem from American Top 40. He was one of the most famous DJs back in the day. In 2007, he was diagnosed with Lewy body disease, which, for those of you who aren't familiar with it, it's similar to Parkinson's with dementia. It sort of has the worst of both. By 2013, Casey's second wife, named Jean, refused to permit Casey's three oldest children from visiting Casey. So that included Carrie Kasem and her brother and sister. The Casey children and Casey's brother held a silent protest outside the Kasem mansion where Jean was holed up with Casey, and Jean called the authorities. Helicopters came, the police came. It was a media circus because of Casey Kasem's fame. In 2014, Jean hid Casey away completely. So in spring 2014, Carrie, Casey's daughter, obtained conservatorship over her dad, and she was able to visit with him. However, he died that June. Jean, for whatever reason, took his body to Norway and hid it there. In 2015, Carrie and her siblings filed a wrongful death suit against Jean. There were some really terrible allegations of elder abuse, such as bed sores the size of a hand, urinary tract infection, no pain medications, no nutrition, et cetera, which may be why she didn't want an autopsy and hid the body in Norway. Anyway, in 2017, Jean turned around and filed a wrongful death suit against the three Kasem children, their lawyer, and the facility where Casey passed away. At around the same time, in 2008, Peter Falk, best known for his role as Columbo, was completely incapacitated due to dementia. He also had a second marriage and children from the first marriage. His wife and conservator, Shira, would not let the Falk children from the first marriage visit with Peter. She didn't tell them when he went into the hospital, nor when he died, and she also buried Peter without telling his children about the funeral. So this resulted in Carrie Kasem and Catherine Falk, becoming politically motivated, and their political activism translated into bills. They drafted legislation with the help of, in Carrie Kasem's case, a California attorney, and Catherine, same thing. In fact, in 2013, Catherine formed the Catherine Falk Organization and proposed a bill regarding visitation known as the Peter Falk Bill. And you can see this information at her website, which is catherinefalkorganization.org. In 2013, Carrie Kasem and Catherine Falk joined forces and formed the Kasem Falk Foundation. However, after 2 weeks, Catherine left. But during that time, 2 drafts of the visitation bills were created. Catherine took one with her, and Carrie kept the other. And this information is at Carrie's website, carriekasem.com, and kasemcoalition.org. In 2015, Catherine Falk, no longer associated with Carrie Kasem, joined with the National Association to Stop Guardian Abuse, known as NASGA. And they introduced the Falk-NASGA Right of Protected Persons Association, and they attempted to do that in all 50 states. And the thrust of the bill was adult-child visitation with their parents. Interestingly, in 2016, there was a 3-day civil trial wherein Carrie Kasem was granted a 3-year restraining order against Catherine Falk. Anyway, in 2017, Catherine submitted some of her language to the Uniform Law Commission, and they took that language and considered it when drafting what would eventually become the proposed SB 19. Currently, the Falk bill has been passed in about 15 states, and the Kasem bill has been passed in about 10. In 2016, Carrie Kasem came to New Mexico and tried to pass what was called House Bill 120, the Adult Child Visitation Privileges Act. It was introduced in the 52nd Legislature and sponsored by then Representative Conrad James. Carrie came and presented to the legislature about her terrible story about not being able to see her father. However, people who opposed the bill opposed it for reasons that it was not right for New Mexico. It would have created 2 tracks for guardianships and conservatorships, one for visitation potentially, and the other for the PQs. So not only were many practitioners in the field against HB 120, the Administrative Office of the Courts also said it would be very expensive and came down against the bill, and eventually it was tabled. In 2016, later that same year, the Albuquerque Journal published its Who Guards the Guardian series by Diane Diamond, in which visitation played a large role. Then in 2017, Desert States and Ayudando, while not having to do with visitation, were accused of embezzling millions in funds from the most vulnerable New Mexicans, highlighting the need for reform in the guardianship and conservatorship law, which everyone across the board concurs. In 2018, as Greg mentioned, Senate Bill 19 was introduced by James P. White sponsoring it, and I think that this is a good place for Felice to talk about the Uniform Law Commission. And
okay. So this past, so last June, the Uniform Law Commission issued the final version of the new guardianship law proposed to be enacted. And New Mexico was actually the guinea pig. It was the first state that tried to introduce it, or that actually did introduce it, even though the committee commentary has not been issued. So I think a lot of people felt a little bit nervous about it. Adding to that was intense political pressure to do something about guardianships in New Mexico, and all in the context of an even year 30-day budget session. The bill was introduced in the Senate, and there were multiple hearings in the Senate. I think that the Senate Judiciary in particular did a really good job of inviting all stakeholders to have meetings and to propose amendments. I think, a big problem from the beginning was whether the judiciary would be appropriately funded to implement the changes. And I think everybody kind of knew all along that that was going to be a big hurdle. Finally, the Senate they proposed a committee substitute bill, which carved out the most expensive parts of the proposal and put them into assigned a delayed implementation. But for the most part, it was pretty much the uniform law, just with a carved out delayed implementation. By the time it got to the House, the Senate voted unanimous approval. It then went to the House. We, at this point, we were watching pretty closely, and we felt like there was a good chance that it wouldn't make it through the House because, there were so many other things going on, and typically bills get heard by two different committees. It went to House Judiciary. It had one hearing, and then a second hearing probably a day before the session ended at noon. And in that particular hearing, there was a series of amendments introduced which completely changed the bill. It basically deleted or removed all of the delayed implementation parts. Interestingly, the House also removed the bill from going to House Appropriations. They said, well, we removed all the expensive parts. It doesn't need to be heard in House Appropriations. So it went to the House floor and passed. Then it went to the morning of the last day of session, where the session ends at noon. It went to conference committee, and the Senate approved of the House amendments. So in a very, very short period of time, the bill changed substantially. And that's what Greg is going to talk about.
I think that the reason why we wanted to spend time on the background of some of this is because in order to understand really what was done in SB 19, the background becomes really critical, at least from my perspective. At the table in the drafting committee for the 2 years that this worked through the Uniform Law Commission was the National Association to Stop Guardianship Abuse, and the visitation voices that Lisa referenced were loudly heard. And it's important that you know that, because ultimately the draft that came out of San Diego in July was the product of debate by a lot of stakeholders. At any given time during the drafting committee process, there would be 30 to 40 people, sometimes maybe even a little more, present. And every one of these provisions that we're going to go through, and some not, were the subject of debate by people who represented these constituencies, including also AARP, the National Guardianship Association, and then a number of very high-profile academics who have written scholarly material on the problems with the guardianship system nationwide. So, as I mentioned earlier, what came out of San Diego was a rewrite of the probate code that dealt with both minor guardianships, adult guardianships, adult conservatorships, and then other protective arrangements. Basically, what the revised act did was rewrite the Article 5 into 5 separate subparts. And it's very comprehensive. I'm not sure, police, but I think it's almost 200 pages, or maybe even a little more. And SB 19, as police noted, originally had all that in there. And so, what came out of the out of the House in the session was really a select adoption of portions of this Uniform Act grafted onto the existing Uniform Probate Code as it's adopted in New Mexico. And so as we go through this, you're going to hear references to the Uniform Act section, but really what the committee did was simply take portions out of the Uniform Act and then place them into the existing New Mexico architecture. So there is not a direct translation into the existing act, or the Uniform Law Commission Act. All right, so let's kind of get into it. There's a lot to cover, and I know that I'm not going to do it justice, but we'll try, and we'll try to get through it as quickly as we can. So some of this is going to be dry, so bear with us. So on your screen now, you should have the clean copy of the act that cleared the House, and we're going to begin going through it. So 45-5107. This is a non-uniform addition to our Uniform Probate Code. It requires a guardian and conservator to not commingle their own funds with funds held by a ward or protected person, and requires that any funds and investments held by the guardian or conservator be kept separate. So you'll see that. And in addition, note on line 21, I don't know if does that work?
Yeah, here, let's see.
Perfect. On line 21, you'll see if a guardian or conservator serves as a fiduciary for one or more individuals subject to guardianship or conservatorship, the guardian or conservator shall hold the funds and any investments held as a fiduciary in a separate account for each individual subject to guardianship or conservatorship. So note that. There does appear to be some distinction on the following page at line 3 between investments and money and other property. And you'll just note that as you go through this, that it appears that those kinds of investment or those kinds of assets are distinguished in the Act. There is also now on line 11, paragraph B, you'll see a non-uniform addition that allows a court at any time to require a guardian to bring a proceeding for a conservatorship if necessary, and there are requirements there for when that should occur. Now, significant to a lot of our practices is line 23, paragraph C. And here you'll see reference to document retention. This is a non-uniform addition to the Uniform Probate Code. The guardian or conservator shall maintain books and records that are in the possession, custody, or control of the guardian or conservator, and that concern the funds, investments, or other property held by the guardian or conservator as a fiduciary for an individual for 7 years, or for such other period as may be provided by the court. So if you work for an institution that has a retention policy that might be at odds with that, you may want to bring that up to your management because that could change the retention policy of your organization. So moving on to some of the other changes. Let's scroll down to line 17. There is now a specific provision for voting rights. This is a modification of the Uniform Act. There was a lot of discussion in the Uniform Act about the removal of the right to vote or the right to marry, and if that was going to be done, it had to be done only under express language in an order. This language here appears to be somewhat of a nod of the head to that, but it doesn't capture it as thoroughly as done in the Uniform Act. All right, so let's move on to, there you go, 45-5303. As you know, this is the primary provision in our existing Uniform Probate Code that deals with the procedure for litigating or initiating a guardianship and conservatorship. So this is substantially rewritten. It will be important for the practitioner to be familiar with this after the effective date, which we'll discuss at the very end of this presentation, because it will affect the way that you go about your business. Beginning with paragraph B, line 3, this is paragraph B, line 3, discusses the contents of the petition. So you'll note in line 4, obviously stating the petitioner's name, address, etc., and relationship is similar to our existing 303, but not completely, because we have an addition of the address requirement. But then as we get further down, in beginning with line 9 and throughout the bottom of the page and then going into the next, what you'll see is an expanded list of persons who are to be identified in this document. That becomes important as we get further down from a monitoring perspective, which was one of the key objectives that came out of the 211 summit I mentioned earlier, and that came out of the Uniform Law Commission in the summer of 17. So let's go now look at line 19, or line 9. Here you see the alleged incapacitated person's name, the information concerning that person need to be in the petition, and then line 16, the spouse, or if the alleged incapacitated person has none, an adult with whom the alleged incapacitated person is in a long-term relationship, and then it defines that. This is significant. Beginning with line 18 down to line 23 is a non-uniform addition. The Uniform Law Commission used the term domestic partner. This is a New Mexico substitute for that term, and I believe is intended to be an expansive reading. But notice that that person would need to be identified in the petition. Going on to paragraph B, adult children would need to be identified in the petition, and then if none, it provides adult siblings, or if none, at least one adult nearest in kinship to the alleged incapacitated person who can be found with reasonable certainty or diligence. Line 4, you'll see a reference to the inclusion of adult stepchildren when they may need to be identified in the petition, and there's a requirement there on line 6 for how long they've got the kind of relationship, or at least defined by time, before they need to be included in the petition. Line 10, paragraph 3, is really part and parcel of the overall architecture of the Uniform Act. And let's just talk about this briefly before I continue. The concept behind the Uniform Act was to expand monitoring by giving more sunshine to filings in a case by specifying persons who would be certain to get information as the case was filed, and then post-adjudication as it rolled forward, with the idea that the more people that have notice, the more monitoring and the less likely things could go wrong. And so as a result, these changes beginning in line 10, paragraph 3, are uniform changes to our existing probate code, and they reflect that exact policy. So you'll see here the expanded list of persons who are to be identified in the petition. And we don't need to go through them, but you'll see line 12, person responsible for care, and then there's a number of individuals identified all the way down through line 25 on that page. And then on to the next page, 6, you'll see a bunch of other folks that need to be identified in the petition as well. Interestingly, line 16, paragraph L, included now with persons who must be notified in the petition are persons known to have routinely assisted the alleged incapacitated person with decision-making during the 6 months immediately preceding the filing of the petition. Footnote here, this really does kind of dovetail with the supported decision-making models that were adopted in the Uniform Law Commission's revised act that didn't completely make their way into New Mexico, but that really was intended to dovetail with that line of thinking. Going to the bottom of that page, there is a couple of places where there is a disconnect between New Mexico's SB 19 and then the Uniform Act, and line 24 is one of those places. The original act required that the petition state the reason a guardianship is necessary, including a brief description of, and then paragraph B originally said whether a protective arrangement would work, and let's just footnote that. So in the Uniform Act that was passed, that cleared in San Diego in the summer, there was an entire standalone section for protective proceedings, which we're going to talk about briefly as we get further. That would allow single transaction or targeted interventions. that section did not get adopted in New Mexico, and we can discuss why, but there actually is going to be a spot where that has significance from a construction standpoint. But here, what looks like was done by the drafters was simply replacing least restrictive alternative for protective arrangements when they're actually not really synonymous, although slightly, but not completely. So moving on then, there are other uniform changes that reflect the concept of least restrictive means, acceptable alternatives in line 8, line 10, and line 13. So you'll need to assert whether the petitioner seeks a limited guardianship or full guardianship. If you seek a full guardianship, the reason a limited guardianship or a protective arrangement, and that dovetails back to that section of the Uniform Act that was not adopted in New Mexico. And then if a limited guardianship is requested, the powers to be granted to the guardian. And all of that is really forcing practitioners to look closely at alternatives to guardianship and least restrictive means, which is undoubtedly where the law is headed without any question. Significantly, let's look at line 15, paragraph 8. This is one of those paragraphs that emanates out of the concerns that you heard Lisa talk about, which is the visitation issues. Rolling forward, what would need to be asserted in the petition is the name and current address, if known, of any person with whom the petitioner seeks to limit the alleged incapacitated person's contact. And again, this goes directly to the voices that Lisa summarized to you at the beginning of our talk. Interesting, what's fallen off in this adoption of the Uniform Act is a requirement that we disclose felony convictions, etc. As you might remember, is in the existing 303, 813. That is not in the this revised version. All right, let's go to. Well, let's just continue through 303 just a little bit more, I guess. Page 8. So page 8 is mostly the existing 303 framework. What is interesting, just from a history standpoint, is that what was rejected in New Mexico was the option of making the qualified healthcare professional evaluation optional. There was some language in the Uniform Act that allowed the court to bypass that if it felt that it had enough information in the file to make an adjudication. New Mexico did not apparently appreciate that, and so as a result, the qualified healthcare professional review remains mandatory. The rest of page 8 is in the existing framework. So section, page 9, line 1, section F, continues with the court visitor. That appointment language is the same as in the existing framework. What was rejected here was an expansive role of the visitor's function, and instead what we have is basically kind of what we already have in New Mexico. So moving forward onto page 10, a lot of that framework remains the same. But what we do have now is very significant distinctions with confidentiality and access to information, which is one of the things that you should specifically look at here. Page 10, line 19. As everyone knows, we're supposed to be able to have the existence of the guardianship publicly discoverable now, at least to some degree, and there has been recent changes along those lines. But nationally, there's been a lot of people having frustration over the ability to access court records. And so the Uniform Law Commission specifically dealt with that, and some of these changes are uniform in nature. Line 19 now says the existence of a proceeding or the existence of a guardianship for an adult is a matter of public record unless the court seals the record after. And the concept here is after the person requests and either their guardianship has been dismissed or on page 11, line 3, the guardianship is terminated. And the idea there is, so if a person has a guardianship in place because of a crisis that's resolved, the hope would be that that would not haunt that person for the rest of their life, and that person would have the ability to come in and get their file sealed. Moving on to line 4K, this is a modification to our existing language dealing with access to court records. This provision would allow an alleged incapacitated person, an attorney designated by them, or significantly, a person entitled to notice to access court records of the proceeding and the resulting guardianship. So while the statute does not say who those persons would be, it seems logical to me to refer you to Section 309, which is the section we'll get to in a bit that deals with notice in guardianship proceedings. And it seems to me that those persons identified there are persons that one would think would be entitled to notice of the guardianship proceeding. Line 10 on page 11 would allow persons not otherwise entitled to notice for good cause to access the court records if access is in the best interest of the alleged incapacitated person or furthers the public interest and does not endanger the welfare or the financial interests of the alleged incapacitated person. And so you can see here now there is the ability for people, even if they're not in the first category of individuals, to have access to the court record. Line 18, paragraph L, allows for the sealing of certain records. You'll see a report pursuant to subsection E and F of this section. That's the qualified healthcare professional and visitor references. Or a report filed pursuant to 303.1, that's the guardian litem statute, is confidential and shall be sealed on filing, but is available to line 22, the court, line 23, the alleged incapacitated person, and then moving on to page 12, the petitioner, and then an exception on line 4 for the agent, and then line 8, and then any other person if it is in the public interest as determined by the court or for a purpose the court orders for good cause. Again, those confidentiality provisions go right to the heart of a lot of public debate now on guardianship, and that's the reason for their inclusion. We have the existing line 11, the existing framework about disclosures not providing diagnostic information, and so that is still in the statute. Line 15 is a sea change for New Mexico practitioners. This specifically states that the issue of whether a guardian shall be appointed shall be determined by the court at an open hearing, unless for good cause the court determines otherwise. Now, there is presently in the works rules that are being created by the New Mexico Supreme Court that deal with the implementation of a lot of these sections, including this section. And so when those rules become active, certainly the practitioner would want to consult those to determine how the court will implement these particular changes. We're not going to cover the rules in this phone call because we don't have time, and they're also not final yet, but just be aware that that is out there. So moving on, Section 309 deals with notices in guardianship proceedings. Again, the idea behind the Uniform Law Commission's revision on the notice was that whoever was identified in the original petition, and remember we went through that, those individuals would be entitled to notice of the adjudicatory hearing. And so you'll see here in Section 309, there is the expansive list now of the individuals who are entitled to notice of the hearing. And so just be aware of that. And you can see that, by the way, if you want to look for the language at line 13, paragraph C, in a proceeding on a petition In a proceeding on a petition under Section 5303, the notice required under subsection B of the section shall be given to the persons required to be listed in the petition under 303 and any other person interested in the alleged incapacitated person's welfare that the court determines. So just note that that is there now, which will add to your administrative tasks as you get ready for your hearings. So let's move on to section 312. 312 is the existing statute that governs the powers and duties of the limited guardian and guardian. And as you'll see, when you compare these changes with the existing Uniform Probate Code as we have it, paragraph A on page 14, paragraph B, page 15, all that is really the same. Where we start to have changes, though, are beginning in page 18 on line 10, paragraph D. So here you'll see, unless authorized by the court by specific order, a guardian for an adult shall not revoke or amend a power of attorney for health care or power of attorney for finances signed by the adult. And then it proceeds to say if these instruments are still in place, then the healthcare decision of an agent takes precedence over that of the guardian, and the same as to finances. And the whole idea here is that one would want to respect the wishes expressed by the person to be protected at a time when they had the ability to express preferences. And so this statute deals with that. This is a uniform addition to the existing New Mexico Code, and it's based on Section 315 of the Uniform Act. The same on paragraph E, right below that, line 24. This is significant for guardians as opposed to practitioners, but for guardians, a guardian for an adult shall not initiate the commitment of the adult to a mental health treatment facility, except in accord with the state's procedure for involuntary civil commitment. Then, beginning on line 3 on page 19, you'll see language regarding visitation. And this is, again, echoing back to the comments that Lisa had earlier. So, Lisa, why don't you cover the changes here as they reflect visitation?
Sure. F is a brand new provision to 312. It is modeled on the original SB 19 that came through, but they amended it somewhat. Basically, if I were to sum it up, I would say if you are a guardian or if you're representing a guardian and you need to limit contact with someone, you need a court order. A guardian is starting on line 3, page 19, F. For a protected person shall not restrict the ability of a protected person to communicate, visit, or interact with others unless authorized by the court by specific court order. That's 1. Or jumping down to 3, you can't limit contact unless the guardian has good cause to believe restriction is necessary because interaction with a specified person poses a risk of significant physical, psychological, or financial harm to the person. So, significant physical, psychological, or financial harm, and if they have a pre-existing relationship with the person for not more than 7 days. So that means you have to rush to court and get an order within 7 days of restricting visitation, which isn't a very long time. If there was no pre-existing family or other type of relationship, you have a period of 60 days in which to get to court and get that court order. Communicate, visit, and interact includes receiving visitors, making or receiving telephone calls, personal mail, electronic communications, including social media or participating in social activities. F2 says you can't restrict visitation unless a less restrictive alternative is in effect that limits contact between the protected person and a person. And that is a provision that I'm going to let Greg tackle.
Well, so I think that what has gone on here is this is one of those spots where there hasn't been a perfect meld between the Uniform Law and SB 19. The original act here dealt with line 11 by saying a protective order or protective arrangement. And so and again, that's not synonymous with less restrictive alternatives. A protective arrangement was specifically contemplated by Part 5 of the Uniform Act, and it got dropped out. And so they changed the term less restrictive alternative. I think that what was intended originally in this, because this is right out of Section 315 of the Uniform Act, I think that what was originally intended was unless a protective arrangement or protective order instead of guardianship was in effect that limited contact between the adult and the person at issue. But unfortunately, it's just it just doesn't line up completely. So it's important to note those time limitations rolling forward for people on the call. Now I'm going to try to whirlwind through. We've only got about 12 minutes left, and there's still a lot to cover. Section 314 on page 20, this is the existing architecture. I don't think that there's much different in much of that. There is a change at the tail end of this, which is a non-uniform change on page 26. And that's at line 14, paragraph E. A guardian of a protected person shall fully comply with the requirements of any audit of an account, inventory report, or property of a protected person. And so again, that is a non-uniform change. I will say before we leave this section that I believe that the Rules Committee is going to be changing the form or the format for the guardianship form. So be looking for that when the rules are finally published. So going now on to page 26, you'll notice that this is citation to our existing conservatorship statute 45-5-404, and this deals with the requirements for filing a petition and then commencing a proceeding for conservatorship. Much of this on page 26 and 27 or 27 is the same. What's interesting is that New Mexico did not adopt the portion of the Uniform Act that allowed a person to file a conservatorship for him or herself. That was the original subparagraph A1, where line 23 is now on your version. That was not adopted by New Mexico. But for the most part, the provisions in this conservatorship statute do mirror the provisions in 303 on the guardianship side, and so that's good. There are some slight variations when we get to page 29, but I don't think they're consequential. Let's see, line 29, line 13. So here, this component is not in the guardianship side, but I am not convinced that I don't know how significant that is. But for the most part, the rest of that page is the same. Page 30, line 18, is also, if the petition includes the name of a proposed conservator, the reason the proposed conservator should be appointed. That's a slight deviation from the guardianship statute as well. But for the most part, the augmented requirements for a conservatorship petition are reflected in the guardianship portions that we just covered. And so same on page 31, notice in conservatorship proceedings, for the most part, these mirror the provisions of section 309. I think there's some slight change, but it's not significant. All right, let's go to page 33 now and look at. So page 32 and 33. Yep, there we are, right here. So this one, I call this up because this is, you'll recognize this as the existing 405.1 that allows protective arrangements that we have presently embedded in the conservatorship side of our Uniform Probate Code. At the Uniform Law Commission, this was expanded to apply to healthcare issues and other issues that were not necessarily financial in nature, with a very comprehensive part. And so instead of adopting that, and I think the time was just a factor. I just think there was so much in the revised act that there just wasn't time to really study it all carefully. So instead of adopting that article, what was done was some of it was incorporated into the existing framework of 405.1, but keeping it only as to financial. And so if you look then on the following page at line 13, this is the laundry list of things that the court may do with a protective arrangement and single transaction authority. I'm not going to go through it all now, but this is largely based on the Uniform Act, but does not extend to medical and healthcare as the Uniform Act did. Significant is line 9 on page 34. And let's spend some time on this. There was a lot of conversation in the drafting committee about the ongoing problem of elder exploitation and how to deal with that. And so this line 9, it was specifically included to work with the protective arrangement to allow intervention to protect a person who is being exploited without having to impose a full conservatorship on that individual, with the idea that the assumption is that a conservatorship and guardianship should not be put into place, and that you would always use either less restrictive methods, acceptable alternatives, or protective arrangements. And so here, line 9 is reference to that in the protective single transaction context. Paragraph C, which follows that on line 13, deals with burdens of proof and how that is dealt with. So you'll see after notice and hearing, pursuant to subsection A of this section, the court may issue an order to restrict access to the protected person, I'm on line 15, or the protected person's property by a specified person that the court finds by clear and convincing evidence. And then here is new language for us practitioners in New Mexico: through fraud, coercion, duress, or the use of deception and control, caused or attempted to cause an action that would have resulted in financial harm to the protected person or the protected person's property, and poses a serious risk of substantial financial harm to the protected person or the protected person's property. So note that language is there. I don't know if it's a hiccup or not, but there is in line 2, page 35, notice that when exercising this authority, the court shall consider the factors described in section 5417. And here it's right there. That a conservator shall consider when making a decision on behalf of an individual subject to conservatorship. The original act actually referenced section 418 of the Uniform Act, which was the substituted judgment section. 417 in our existing framework is the general fiduciary duties section. So I'm not sure that really kind of cleaned up real well. I think the idea here, at least I thought, was to have the court consider the preferences that the person would have made had they been not exploited. But instead we have the 417 section. But significantly, though, we've got now in paragraph F on line 11, we have that language, which is a non-uniform change, which I think maybe seems to clear up what may be a discrepancy in that statute. So moving on now, The procedure in 407, line 35 and 36, mostly the same. All that's good and the same all the way up to page 40, which is where we have the same provisions, with the exception of another hiccup, but the same provisions for confidentiality and access, largely mirroring the language in the guardianship section, which is a change. So please note that at page 40, beginning line 18 and continuing through page 41. There is an oddity in paragraph O, line 18 on page 41. And the language beginning on line 21 through the bottom of that section looks a lot like the language in the guardianship portion that we talked about, dealing with the sealing of guardian ad litem, visitor, and qualified healthcare professional reports. I can't help but think that the intention there was to make those reports sealable in the conservatorship side as well. But interesting, the reference to 409, I believe, is a reference to the annual report statute. And so there seems to me to be a little bit of an issue, but I think the Rules Committee will probably deal with that. And then the same thing for the hearing access on page 42, as we saw in the conservatorship side. So I am going to whiz through to get to what is probably most significant left, because there's some minor stuff, but let's go to page 46 and look at the waiver of liability statute. This is at line, you'll see there, line 22, 5-409.1. And it states, no person shall request, procure, or receive a release of waiver of liability, however denominated, of a conservator. And then it says that in paragraph B on the next page, a release or waiver of liability that is requested, procured, etc., is void if it's done contrary to that section. This is a completely non-uniform addition to the Act. This was not in the Uniform Act at all. A question as to how far this extends. In my view, a release or waiver of liability is a lot different than a court order approving an accounting. And so my personal judgment, for whatever that's worth, it's probably not worth very much, is that this would not apply to court orders approving accountings. There are, moving on now, and we're just about done, and I appreciate you staying with us. There are, on page 47, new bonding requirements that is beginning at line 9 that are largely driven by the language of the Uniform Act. Note at line 17 on page 47, except as otherwise provided in subsection C of this section, the court shall not waive the requirement of a bond if the conservator is in the business of serving as a conservator and is being paid for the conservator's service. So note that. Note line C on page 48 as we scroll down. This is an exception to a financial institution that possesses and is exercising general trust powers in New Mexico is not required to give a bond under this section. And so, and the rest of that section dealing with bonding is uniform in nature. Finally, as to bond, and we're almost finished, line 5, page 49, you'll note that if a bond under this section is not renewed by the conservator, the surety or sureties immediately shall give notice to the court and the protected person subject to the conservatorship. And so that is hopefully a safety valve that if the bond lapses, interested persons will know. Finally, last but not least, we have the section 16 on page 19 deals with the effective date. So, which is what everybody wants to know, when does this stuff come into effect? A proceeding for the appointment of a guardian or conservator or for a protective arrangement instead of a guardianship or conservatorship commenced on or after July 1, 2018. So that's the critical date. and it applies to a guardianship, conservatorship, or protective arrangement instead of guardianship or conservatorship in existence on June 30, 2018, unless the court finds application of a particular provision would substantially interfere with the effective conduct of the proceeding, et cetera, et cetera. So there were some things that we skipped over, but hopefully we hit all the main points. It is 1 o'clock. I'm sure that either Lisa Milich, Felice Rael, or myself, we'd be happy to take questions later. And if you have questions about this, feel free to give any of us a call, and we'll do our best to answer them. But I think I speak for all of us when I thank you for being on the call, and we'll be in touch. Thank you.